It's Monday, and that means another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about lawyers acting without instructions. Cases that should have gone to the Supreme Court of Canada, but didn't. Georgina Mascaras was a lawyer who represented somebody who'd been seriously injured. As a result of their injuries, they were comatose, and ultimately the family of the injured person decided to take them off life support. Ms. Mascaras filed an application on behalf of her client, without any instructions from her client, who was incapacitated and unable to give instructions, to prevent this from occurring. During the period of time while the application was being litigated, Ms. Mascaras was able to prevent her client's body from being used for organ donation because his condition deteriorated so badly that the organs were no longer viable. Ultimately, the court rejected the application, and the party who is now deceased was taken off life support. The problem that arose for Ms. Mascaras was that she did all of this without instructions from her client. And then now that her client was deceased, she appealed that order to the Court of Appeal, which rejected her appeal on the basis of the fact that she couldn't have proceeded on that basis, and in any event, it was moot. The guy was dead. Ms. Mascaras was also ordered by the Court of Appeal to pay the costs of the litigation personally for behaving in an unprofessional and improper fashion by acting without instructions from her client. She appealed this to the Supreme Court of Canada, and the Supreme Court of Canada dismissed the appeal. The reason that this case is so important is because it really clarifies what role a lawyer plays in representing their client's interests. Obviously, being alive is kind of within one's client's interests. And so the notion that a lawyer acts without instructions to try and keep their client alive seems to be a little inconsistent with the whole needing to be alive thing. But also, when you appeal those orders after the fact, should you really be punished with an order of costs made against you personally as a lawyer for trying to clarify something in the law that directly relates to whether or not your client can continue to live? Is it not better that lawyers, when they have these opportunities, should take the opportunity to clarify the law, to make sure that the law can be applied fairly, and to ensure that people whose interests maybe can't be protected because they can't speak for themselves can have that protection through their lawyers? I don't think that Ms. Mascaras' heart was in the wrong place when she made the decisions she did in this case, but unfortunately, the Court of Appeal disagreed. The Supreme Court of Canada could have clarified how lawyers are supposed to deal with situations like this in order to balance their interests in their clients' lives against the need for finality in litigation once somebody is deceased. The Supreme Court of Canada had an opportunity here to make things a little bit fairer for people who can't speak for themselves, and unfortunately they missed that chance. You're watching cases that should have gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Brazen Bull Creative is responsible for putting these videos together. Please like, subscribe, follow, and share with your friends.